288-627. I will present the answer of questions 1. The guarantee document prioritizes the bank interest by outlining terms that held the defendants, which is guarantors, strictly liable for the debt. Their liability was unaffected by changes to the effective cost of funds rates, and the bank could adjust interest rate without their consent. The bank statement of account was deemed conclusive evidence, placing the burden on the defendants to prove errors which they failed to do so. Additionally, the defendants were treated as principal debtors, making them directly responsible for the debt. The guarantees were classified as additional securities, remaining valid regardless of other securities created. The bank could recover the entire debt without exhausting other remedies or disposing of other securities first. These provisions ensured the bank's ability to recover the debt efficiently while limiting the defendant's ability to dispute or delay repayment.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Iqbal Mesadai. My market number is 288914. So, what the issue that raised by defendant in this case study? There are 4 issues that defendant raised in this study, which are: firstly, plaintiff failed to demonstrate the principal and ECOF rate. Second, plaintiff failed to notify the defendants about the charge. Thirdly, plaintiff should distribute the liability and underdue. And lastly, plaintiff has not fully disposed of security. For the first issue, the defendants argue that plaintiff failed to demonstrate the principle in notice of demand and termination, but this argument is irrelevant. So both notice has been qualified and deposit should be stopped. Next issue, the defendant claims that plaintiff failed to inform them about the charge in the ECOF rate. The PSP agreement to vary interest and provide guarantors liability. For third and that issue, the court ruled the defendant liability under first and second facility was principal debtor, not just surety, and their guarantees were additional securities. That's all for me. Thank you. Assalamualaikum.
Assalamualaikum and good morning. My name is Siti Nasuha binti Muhammad Rasadi. My metric number is 285346. I will summarize the enforceability of guarantee in the case involving Bank Pembangunan Malaysia Berhad. The court ruled that BPMB was entitled to enforce guarantees due to the loan default based on key factors. First, the defendants signed joint and several guarantee agreements as principal debtor, meaning their ability was unaffected by change in interest rate or the status of other security held by BPMB. Second, when the borrower default on RM277 million, BPMB issues notice of demand and termination. The defendant did not dispute their disclaim early, which the court viewed as implied admission of ability. Third, the guarantee agreement includes a conclusive evidence clause. BPMB account statements were accepted as proof of debt unless the defendant could show money-first error, which they failed to do. Lastly, revision to interest rate were with BPMB rights, as stated in the agreement, and did not require the defendant consent. The court found no material issue for a full trial, guarantee BPMB summary judgment, and ordering the defendant to pay the debt along with RM8,000 in cost. In conclusion, this case highlights the importance of carefully drafted guarantee agreement and the enforceability of their term in case of default. That's all from me. Thank you.
Okay, nice. For the question 4 answer is, based on the case study, the defendants do not have valid grounds to argue that the plaintiff failed to inform them about change to the effective cost of fund terms. the contractual terms and establish legal principle binding the defendants as guarantor make this claim untenable. The defendant assurance plainly declare any change or alteration to the loan terms, including interest rate adjustment, will not impair or discharge their liability. Specifically, Clause 5.5 of Term Loan Facility Agreement, date 23 May 2007, and Clause 3.5 of the Facility Agreement, date 15 December 2010, specifically enables the plaintiff to modify the interest rate without the guarantor approval or notification. This agreement also held the defendants liable as primary debtors, which means they could not avoid their commitments even if they were uninformed of the alteration. Once the loan facility was terminated on 16 May 2017, the plaintiff was no longer obligated to issue further notice about the rate adjustment to either the borrower or the guarantors. In summary, the defendant's argument about not being informed of rate change hold no merit either legally or contractually. The plaintiff adhered to the agreed terms, and the defendants are bound by their obligations under the guarantee arguments.
Defendant 1 and Defendant 2 accepted liability as principal debtor, meaning they were treated as if they had directly borrowed the fund. Their liability persists regardless of the borrower's performance or change to the loan terms. The guarantee stated that any changes of the loan term, including interest rate, would not affect the liability of Defendant 1 and Defendant 2. The bank was not required to exhaust other remedies, such as pursuing the borrower or other securities before enforcing the guarantees. Certified bank statements were deemed conclusive proof of indebtedness unless Defendant 1 and Defendant 2 could demonstrate a manifest error. The court upheld the guarantees, emphasizing that there were binding agreements accepted by Defendant 1 and Defendant 2. The defendant failed to provide evidence of error in the bank's record or raise valid defenses. Rendering their claims indicate the guarantee imposed independent and unconditional liability on Defendant 1 and Defendant 2. The bank retained the right to enforce repayment without preconditions, ensuring the guarantee enforceability.